I want to briefly finish what we were discussing at the end of the last class before spring break. And we were talking about what constitutes the practice of law. So we've already talked about the first three in pretty much detail: court appearances, conducting depositions, signing pleadings. So make sure you read the chapter on that, review your notes. You're good with that. The last thing we talked about was giving legal advice. And I just want to go over it briefly because we only discussed that at the end of class, and I apologize if you are hearing dogs barking in the background at the moment. So giving legal advice. It is very important that you are able to define what we mean by giving legal advice because, as I mentioned before, I think this is the one area more than any others where you're going to find yourself potentially in situations where you're asked questions that you might not be authorized to answer, even though you might know the answer, or it's very easy to forget in a conversation sometimes what the parameters are. And so we want to be able to articulate a definition. And as I mentioned this in class, you have the four-part definition that we've already looked at that's in the textbook. You will need to know that. You will be asked that on the next test. You'll be asked that on the final. What are the four different activities that make up giving legal advice? And so, again, they're recommending a course of conduct or a particular action to a client, evaluating the probable outcome of litigation or negotiations or any proposed action by a client, outlining legal rights and responsibilities to a client, and interpreting and applying statutes, decisions, or legal documents to a client. So those are the four different components that make up giving legal advice that you need to feel very comfortable with. What you'll notice that all four of those have in common is it's all dealing with information that would be specific to a client's particular legal situation. So the more specific the information is, the more likely it is legal advice. The more general it is, where the courthouse is, explaining generally what happens at a deposition, those types of things, the more general information, that would not ever constitute giving legal advice. If you are ever uncertain, err on the side of caution and just either tell the person you cannot answer that question because you're not an attorney, or if you're talking to a client, just advise the client that you will consult the attorney and one of you will get back to them. It protects you, it protects the client, it protects the attorney. And even if you do run into someone who gets frustrated because you can't give them the answer, it's still a much better situation to have them a little frustrated than to have you step too far into this area and potentially face ramifications because you have given legal advice. And the last area that constitutes the practice of law is establishing the attorney-client relationship and the fee arrangement. So we've already talked a little bit about the fact that the attorney has to have established and maintained the relationship with the client. The attorney just can't delegate all responsibility to a paralegal. They have to maintain that relationship with the client. A lot can be delegated to a paralegal, but not the ultimate responsibility for the case. So even though the paralegals can do the initial intake, can draft the engagement letter or client retainer agreement, and can be involved in numerous facets of the representation, it has to be the attorney that sits down with that client and says, this is what we can do for you, this is what our fees are, and to have that conversation with the client. So it is an extremely important part of the representation, because if you don't have that properly established, it's going to potentially cause a lot of other issues down the road. So, so when the contract is between the attorney who is either representing himself or the firm and the client. So it has to be an attorney who is involved in that negotiation, so to speak, of what the representation is going to entail and how much it's going to cost the client. Also keep in mind, when they're having that conversation, the client's going to be asking a lot of questions about their case, which will constitute legal advice. So it needs to be handled by the attorney. Now, if you have an attorney that does, say they do some cases for a flat or fixed fee, and they say, yeah, you can let anyone who calls in tell them that I do a simple divorce for $300. If you're authorized to do that, you can do that. But when it actually comes to signing the paperwork and having that the formal contract established, the attorney needs to be involved. And so that is the end of the Chapter 3 in UPL, and this is what we would have covered had we had class on Tuesday night.